we have a little bit left for your EU competence. We will finish that, and then we will move to the sources of European Union law. Okay? Good. We will be speaking about 3 principles which are applied in the exercise of EU competence. 3 main principles which are applied in the exercise of EU competence. You know one of them, you have heard 2 others. So, the first is the principle of limited powers. The principle of subsidiarity and the principle of proportionality. The principle of limited powers is well known. It means that the institutions of the European Union can only exercise the powers given to them by the founding treaties, and they can also exercise those powers within the limits of the founding treaties. Therefore, the EU institutions can only adopt the instruments within the boundaries of the founding treaties. The Council, for instance, knows how to act depending on the related treaty article. It may act by unanimity or by qualified majority or simple majority when it is required by the related treaty provision. It may act under the ordinary legislative procedure if it's so required under the treaties. Sometimes it may consult to the European Parliament. They may act on a proposal from the European Commission. The European Parliament may act by simple majority. They may adopt a regulation, a directive, or a decision, depending again on the related treaty provision. If the institutions of the European Union exercise their competences against the related treaty provision, what would happen? Imagine that the EU institution adopted an act without taking the related provision of the treaties into consideration. What could happen? Would this be an action for infringement? Yes, Deniz?
It might be action for annulment.
Annulment. Action for infringement is always against the member states of the European Union. Action for annulment could be taken before the Court of Justice of the European Union. The second principle is the principle of subsidiarity. We have spoken about the principle of subsidiarity when we spoke about the Committee of the Regions, as you would remember. The Committee of the Regions is the guardian of the principle of subsidiarity. Do you remember what this principle is about, the principle of subsidiarity?
We have to look at whether the competence is better exercised by the member states or EU institutions, and then we will decide. I mean, not we, but I think the European Court of Justice will decide.
But for this question, that whether the member states or the European Union will exercise competence, we have to be in the area of
Shared competence.
Or now non-exclusive competence of the European Union. Because if the competence is exclusive for the European Union, who will adopt legislation? European Union. Would there be a question of whether who will legislate here? No, it is for sure the European Union. If it is the member states' exclusive competence, will we have the question of who will legislate? No. It is always the member states.
There is a consultation, right?
Sorry?
There's a consultation of European Union anyway.
No.
If it's exclusive or...
No? No. Okay, in very general terms, this is the area of exclusive EU competence. Okay? This is the exclusive member states competence. This is the shared competence and the competence to support, supplement, and coordinate the competences of the member states. In the area of EU exclusive competence, will we have the problem of who will legislate? No. Why? Because here, the transfer of power from the member states to the European Union is absolute and irrevocable, meaning that the member states, as a principle, do not want to adopt any binding legislation in these limited number of areas, in the 5 number of areas, okay? So here we will have no question the EU will legislate. In the areas of exclusive member state competence, there is no transfer of power, okay? They want to keep these areas to themselves and they want to adopt binding legislation. These are very few areas at the moment, very few. Even the criminal law is now partly transferred in the area of criminal law. But still, there are certain areas where the member states adopt binding legislation. There, will we have the question of who will legislate? No, it is the member states. But even when they are legislating in these areas, they have to be bound with the principle of that we've mentioned in class, that even if the member states are legislating themselves, they are bound by this, the principle of loyalty, meaning they have to take the objectives of the European integration into consideration. In other areas, mostly in the area of shared competence, we have this question, who will legislate, okay? Therefore, the first requirement for the principle of subsidiarity is that it has to be in an area which does not fall within the exclusive competence. If the EU shall act if the objectives of the proposed action, cannot be sufficiently achieved by the member states, the objectives of the proposed action cannot be sufficiently achieved by the member states, but can rather be achieved by the EU. Therefore, for this principle to be applied, there are 2 questions to be answered. The first is that, is this area in question a non-exclusive competence area? If yes, then comes the second question. Can the objectives of this proposed action be better achieved by the EU or by the member states? If the objectives of this action is better achieved by the EU, then the EU shall adopt binding legislation. This is the interpretation of the principle of subsidiarity by the Court of Justice of the European Union. Therefore, when applying the principle of subsidiarity, the court applies these 2 criteria. Is the area can the area be considered under the non-exclusive EU competence? And if yes, then can the objective be better achieved by the EU or by the member states? The aim here is to adopt legislation which is closer to the EU citizen. Which action? Member state action or the EU action is much better for the individual, for the interests of the individual. All right?
May I ask a question? But the Court of Justice will decide whether the competence will be used by the Union or member states, right?
Okay, it goes like this. First institution that takes the principle of subsidiarity into consideration is the European Commission. Why? Because it is the institution that initiates legislation. Therefore, it is the first institution that prepares the legislative draft. If you see a piece of legislation, EU legislation, for example, a directive or a regulation, let me explain you like this. Say this is an EU regulation on environment protection, okay? Every EU regulation starts with a preamble. Any ideas what a preamble is? Ön söz, which is not binding, okay, which is not binding. It is better translated as dibace, which is also Turkish, doesn't sound Turkish, but it is the part of a piece of instrument, here a regulation, before Article 1, okay? This is the part where the EU legislator explains the aims, the scope, the procedure that is followed, the reasons why this instrument is adopted, etc. When they are adopting an EU regulation in an area which is not exclusive, they also have a paragraph. These are divided into paragraphs, and there is always a paragraph which is about the principle of subsidiarity. Therefore, when the Commission first prepares this proposal, it also justifies why it proposed such an instrument. It has to say because the principle of subsidiarity is taken into consideration, and in the opinion of the Commission, the EU has to adopt such an instrument because, okay? And you know, before its adoption, secondly, it is considered by the Committee of the Regions as well, that the Committee of the Regions also takes account the facts on why the EU has legislated in this area. And yes, you are right, at the end, when there is a problem on the principle of subsidiarity, eventually it will be the decision of the Court of Justice that will tell whether the principle of subsidiarity is satisfied or not by the European Commission, for example, when preparing this act.
If they couldn't decide.
Of course, when there is a dispute, this could be a claim from a member state as well. It will be in most of the cases. The member state will say the principle of subsidiarity is not applied in a proper way. They might say it is the competence of the member states here because the aim of the proposal could be better achieved by the member states.
Okay.
All right. The third principle is the principle of proportionality in Turkish, ölçülülük veya orantılılık. According to this principle, both of the principles are provided under Article 5 of the EU Treaty. And according to the principle of proportionality, the form and the content of the EU action, shall not exceed what is necessary to achieve the objectives of the founding treaties. The content and the form of EU action shall not exceed what is necessary to achieve the objectives of the founding treaties. Therefore, in the application or in the implementation of the principle of proportionality, we both look at the content and the form of the EU action. The means and the ends should be proportional. The means and the ends should be proportionate. What do we mean with this? That the content of the EU action should be in conformity with the founding treaties. It is the objective, the purpose of EU instrument, EU legislation, okay? They should be in conformity with the objectives of the founding treaty, nothing more and nothing less in terms of the content of the instrument. The form also has to be taken into consideration. By saying form, what do we mean?
Şekil.
Yes, and what do we mean? No, şekil. And what do we mean? Usul is procedure. Yes?
It's like, I don't know.
It is that if it is sufficient to adopt a directive or a regulation, for example, don't make any amendments of the founding treaties. Okay? If it's sufficient to achieve this aim, if you will reach this aim by only adopting a regulation, then there is no need to make an amendment on the founding treaties. Okay? Therefore, the form of the action should also be proportionate. What are the differences between the principle of subsidiarity and proportionality? What do you say? These are two principles provided under the same protocol, now annexed to the founding treaties, but there are two important differences between them. Yes, Deniz?
In the principle of subsidiarity, we will look at who will exercise the power or competence. But in the principle of proportionality, we decided who will exercise the competence, but in which forms and in which extent.
Who exercise the competence in the principle of proportionality?
Will exercise the competence.
Who?
Union.
The EU will exercise, okay. It's true. In the principle of, this is the first difference, in the principle of subsidiarity, or the principle of subsidiarity is about who will legislate, who will exercise the competence, the EU or the member states. In the principle of proportionality, we have the question of how the EU will legislate, how the EU will exercise its competence. This is the first reason, difference. What is the second? Yes, Öykü.
I think the principle of subsidiarity cannot be applied to the exclusive areas of the European Union. However, principle of proportionality can be applied to everywhere.
Exactly. The principle of subsidiarity applies only in the non-exclusive EU competence areas, when the EU's competence is not exclusive. The principle of subsidiarity can be applied. On the contrary, the principle of proportionality applies in all areas of EU competence, even if the EU exercises exclusive competence, it has to act proportionally. True? Yes.
They include each other.
Sorry?
They include each other. Even if EU acts in the principle of subsidiarity, it should act in the principle of proportionality.
Yeah. After applying principle of subsidiarity, you have the conclusion that the EU should exercise the competence. Yes, then the EU should exercise that competence proportionally. All right. Any questions? No questions about the areas of competence? No? Yes, Öykü.
We said that in our last class there are three areas, and I didn't write the exclusive member state area.
Yes.
But you wrote it there.
Yes, because the founding treaties do not provide anything about exclusive member state competence.
But it exists.
Of course.
Okay.
It is. I told this one time. I don't know when. The exclusive EU competence, the shared competence, the competence to supplement, coordinate, and coordinate, supplement, and support the competences of the member states. These three are provided. But naturally, exclusive member states' competence is not provided in the EU's founding treaties because
it's
nothing to do with the European Union. It has got nothing to do with the EU. The EU regulates these three areas, but it has the main principle of loyalty to regulate this area only. Other than this, the exclusive member state competence is provided in the national laws of the member states. All right? Okay. Anything else?